Good morning and welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who are joining us on our heritage.org website on all of these occasions. For those here in-house, we would ask that courtesy check that our mobile devices have been silenced or turned off as we begin. And of course, those watching online are welcome to send questions or comments at any time, simply emailing speaker@heritage.org. Leading our discussion today is James Roberts, who is Research Fellow for Economic Freedom and Growth in our Center for International Trade and Economics. His primary focus is the production of Heritage's annual Index of Economic Freedom. He also studies economic and political issues in Latin America and Europe, as well as development assistance and nation-building issues. Before joining us here at Heritage, he served at the State Department for 25 years, with tours of duties at U.S. embassies in Mexico, Portugal, France, Panama, and Haiti. He also helped coordinate several major U.S. assistance programs, including efforts to reform Eastern European economies and to reconstruct Iraq. Please join me in welcoming James Roberts. James?
Good, thank you. Thank you, John. Thanks to everyone for coming. It's great to see a good turnout for this important subject. Several years ago, when my Heritage colleague, Dr. Ted Broman, along with one of our experts on the panel this morning, began writing about ISDS in the context of the TTIP negotiations, I don't think we could have imagined that the profile of this issue, investment dispute settlement, would have become as elevated as it is today. At first glance, it's rather dry and arcane, but this is an important subject. One that has been around in various forms for a long time at the World Bank's ICSID and elsewhere. In my years as an economic officer in the Foreign Service, we almost took it for granted. For us and for our partners and friends in countries with which the United States has extensive trade, it was more or less non-controversial, an element of our trade and investment relationship. Common sense, really. Our trade partners generally shared our view that trade helps both sides, and that the guarantees and the certainty that investment disputes could be settled quickly on the merits of any given case would improve the investment climate. ISDS actually reflects the core principles guiding our annual Index of Economic Freedom, and it has been at the heart, really, of the Heritage Foundation since its founding in 1973, and that principle is free trade. Trade and investment between foreign and domestic private sector individuals and companies strengthens institutions in emerging markets. That is one of the main reasons that the United States and many other OECD countries have promoted the WTO and free trade agreements around the world for many decades. Stronger institutions improve the political stability needed for greater wealth creation and better living standards. They improve the rule of law, which is one of the 4 pillars in our Index of Economic Freedom, and the one that I work on. To achieve those desirable outcomes, we must ensure that private companies are incentivized to take the risks of investing in countries where the rule of law is not as strong as it is here at home. For example, countries such as Argentina, Venezuela, Egypt, Russia, and Ecuador. We would argue that people in those countries today are generally better off than they might have been because of foreign direct investment. And promoting FDI is a key reason why ISDS provisions have been included as important features in FTAs. The consensus about the importance and value of ISDS has been breaking down, however, and its higher profile has provided a good reason to have a discussion about it this morning. To do that, we have with us perhaps the best panel ever assembled to talk about ISDS. Okay. I use no hyperbole. Without ISDS, companies have to lawyer up and fight costly and lengthy court cases. So who better to discuss ways to avoid that ugly prospect than 3 lawyers? To lead off and outline the policy considerations and state of play of ISDS provisions in the NAFTA, we're honored to have with us Dr. Gary Hufbauer. As the old cliche puts it, Gary Hufbauer really needs no introduction to the Washington, D.C. policy community. The Reginald Jones Senior Fellow at the Peterson Institute for International Economics, Dr. Hufbauer was previously the Marcus Wallenberg Professor of International Financial Diplomacy at Georgetown. He served in the Treasury Department, has a BA from Harvard, a PhD from King's College, Cambridge, a JD from Georgetown, and has co-authored publications that include Economic Sanctions Reconsidered, U.S. Taxation of Foreign Income, U.S.-China Trade Disputes, and others. Too long to mention, really. So we'll hear from Dr. Huffbauer first, and then we will hear about perspectives on ISDS from the American business community from Linda Dempsey. Linda M. Dempsey is the Vice President of International Economic Affairs at the National Association of Manufacturers. In this capacity, Ms. Dempsey leads the NAM's efforts to improve global competitiveness of manufacturers in the United States by advocating a wide range of policies, legislation, and international agreements, including to open up foreign markets and remove red tape at the border, to promote transparency, protect intellectual property, and investment. You could be one of our editors of our index. Huh? Linda has spent more than 25 years on international trade and investment policy, was previously Vice President of the Emergency Action for American Trade, Chief Minority Trade Counsel for the Senate Committee on Finance, and a lawyer in private practice with firms focusing on international trade and investment. A native of Pennsylvania, Linda went to Penn State in political science undergrad and earned her law degree from the Bolt Hall School of Law at the University of California at Berkeley. Finally, but just as importantly, we're joined by Dr. Riddhi Sohan Dasgupta, who will share with us a detailed legal analysis of ISDS. And he's a good guy to do it, since he literally wrote a book about it. We're so pleased and grateful that he took the time to travel here this morning all the way from Sacramento, California. As a law student, Dr. Dasgupta served as executive editor of the Harvard Journal of Law and Public Policy, the executive editor of the Berkeley Journal of International Law. He's also the author, as I mentioned, of the monograph entitled International Interplay, The Future of Expropriation Across International Dispute Settlement. He also served as the chief draftsman of the draft constitution for Tunisia after the Arab Spring on behalf of a think tank. During law school, Sohan served in the office of the Solicitor General of West Virginia and at a multinational law firm. He has a bachelor's in economics and industrial engineering, operations research, and history from Columbia, a master's in social policy from Oxford, a PhD in international law from Cambridge, and a JD from University of California, Berkeley. And Sohan won the Congressional Gold Medal for Youth at the age of 22. So, quite a resume. So we're delighted to have them and you here, so let's get going, and we can hear from Dr. Huffbauer. You can either speak at the podium or from the chair. Thank you.
Well, Jim, thank you very much, and it's great to be back at Heritage and see my old friend Brian here and many others. So, you know, as Jim said, I was surprised, and I guess many of us were surprised that this really got into the debate in a heated way starting in about 2015, so about 2 years ago. ISDS suddenly leapt from the kind of very detailed area of international law into the public debate. And it has collected a very odd group of opponents, and I'm just going to say a few words on them. But it's been around since about 1959 when Pakistan and Germany signed an agreement with an ISDS feature in it. And according to a count that I looked up a couple of years ago, more than 2,000 agreements have an ISDS feature. So it's, you know, it's very widespread between many countries around the globe. And there's the arbitration group within the World Bank that Jim referred to. There are other alternative panels in Stockholm and London. So things seem to be moving fairly smoothly, and then suddenly it came into notice. So 3 groups of opponents. The first, which just issued a screed the other day, but has been a long opponent, is the Ralph Nader organization known as Public Citizen. And, you know, their philosophy is actually pretty simple, so you don't need to read the details. Basically, anything that helps corporations or might help corporations must be bad. So ISDS might help corporations, and therefore it's not good. And Public Citizen has said that absolutely, if NAFTA is renegotiated, the ISDS chapter has to go. This echoes what Senator Warren said back in February 2015. She kind of launched the current debate in the public eye, though there's been debates in the scholarly literature prior to her remarks, and she calls it a corporate giveaway. ISDS is a corporate giveaway. If you actually read what she had to say in her op-eds and so forth, she invents a lot of hypotheticals of cases, that might happen. She doesn't have any actual cases, but hypothetical cases that might happen, and there'd be some big award trampling on environmental or health rights or the rights of workers, whatever. That was her basic idea back then, and she's continued to pursue it, not successfully in the Congress, but certainly amongst her followers. So that's one opposition. Then on the opposite side of the, let's say, the political spectrum would be my friends over at the Cato Institute. And so this even surprised me a bit more, but they are against it. My good friend Dan Ikinson and some others are not in favor of ISDS, and they have a very different kind of reasoning. It's that this would give foreign countries the benefit of U.S. concepts of property rights and international law and fair treatment. And why do that? Let the foreign countries earn it. Don't let them get it on the cheap by signing an ISDS agreement in a free trade agreement or a bilateral investment treaty. Those are the two vehicles that have been used in many more bilateral investment treaties than free trade agreements, but both of them have similar language, though not identical from agreement to agreement. Well, the Cato scholars acknowledge that there are a lot of problems with court systems in many countries, sometimes in our own country. But in many developing countries, the two key problems are, one, corruption, quite widespread, and two, just delay. I mean, here you've got a firm which might, through some regulation, have lost effective use of its property, and it brings a case in the local courts, and 9 years later it still isn't resolved. So, justice delayed is justice denied. And Cato acknowledges that, but they say, look, these countries have to raise their own standards in order to be entitled to attract investment, and if they don't, that's kind of too bad for them. Now, then the third opponent, and this is politically the most important, turns out to be the current administration. And speaking through Ambassador Lighthizer, they seem to have two arguments, or really one argument, that the ISDS provision, which provides for arbitration by experts, that's good. That's good. Hey, this is good.
That's an incredible gag.
No extra charge for the
Campfire on the
entertainment.
No. This is great. A little amusement. Now, this. I was just up in Toronto yesterday. We were talking about Venezuela, and some supporters of Maduro came to the stage. You wouldn't think there are, but there are up in Toronto, and they unfurled banners saying hands off Venezuela. Most of the crowd, of course, thinks that Maduro is a complete dictator and crook. So that was very lively, but this is kind of a new high tech. We'd expect high tech here.
We're on the cutting edge.
In the cutting edge. Well, that's good. Okay, so Ambassador Lighthizer is concerned about U.S. sovereignty. Now, there's kind of a broad concern among some people that sovereignty gets intruded upon whenever we have an agreement. And we have thousands of, probably thousands, at least hundreds of treaties and trade agreements and so forth. And you could say any agreement with a foreign country somewhat limits your sovereignty, because the idea is you're not going to do certain things that you might otherwise have done. That's the nature of an agreement. So you could say that's a broad concern they have, but it's a more focused concern in the case of Ambassador Lighthizer, that to have the agreement interpreted by a panel or a court system other than the U.S. court system is you could say, a double intrusion of sovereignty. And these arbitrators, of course, are not just federal district courts or any other court of appeals or anything else. And so he's concerned about that. And that concern also extends, in his view, to the WTO. He's not very favorable towards the WTO dispute settlement body and the appellate body and all that. But ISDS comes within this same umbrella of concern. Now, I think this sovereignty issue that is the umbrella really cloaks another argument that, unfortunately, the Trump administration seems to have globbed onto, and that's a zero-sum view of investment in the world. If a company invests abroad, it's not investing in the U.S. dollar for dollar. Now, the econometric evidence that we've done and others have done simply do not subscribe to that view, that companies which invest abroad invest more at home than other companies with similar characteristics which don't invest abroad. They have more exports, they do more R&D and so forth. And I could go into the model of that, but I won't. That would be a little bit tedious. But in any event, their view is a resolute 0-0 or zero sum. So with that, why do anything that might make it easier for U.S. companies to invest abroad? And I think that's the underlying concern there. So they have come up with this very, what I would say, odd idea for NAFTA, but is essentially a way of getting rid of ISDS, allowing any country which is a party to NAFTA to opt in to the ISDS provision. In other words, we can have a kind of a section on ISDS, and then each country can decide whether it wants to apply it or not within the country, and maybe on a case-by-case basis, maybe on a time basis, maybe more generally. Well, of course, that would kill the system. So there we have it. These three groups of opponents who come from very different ideological positions have kind of amalgamated in opposition to ISDS and made it a big political issue. I think I've used up all my time, but let me just say that if the United States abandons ISDS in the NAFTA talks, this is a tremendous retreat from advancing the rule of law on a global basis. And in particular, there's China. And everybody knows how big China is, and China does not have the rule of law, especially with respect to investment. And if we abandon it in NAFTA, how can we pursue it with respect to China, which we've been trying to do for about a decade in the bilateral investment treaty? Not only China, but that is the big prize. So it just kind of boggles my mind that we would be thinking of jettisoning it at this time. Let me just say a word about the size of awards within NAFTA, which has been, Jim and his colleagues have assembled the data on this, but it's only about 100 million of awards, none against the U.S., both against Mexico and Canada. Well, 100 million would be a lot of money if it were in my pocket or your pocket, but it's not a lot of money compared to the size of foreign direct investment between the U.S., Mexico, and Canada and all three directions, which is in the rough vicinity of 500 billion. So it's a very small amount of cases, but each of these cases helps define the line between what is inappropriate government behavior and what is appropriate. And that line needs to be drawn. And if you're in favor of investment, which I very much am, this is an essential ingredient. Thank you very much.
Thank you so much, Gary. Now, next we turn to Linda.
Great, thank you. A pleasure to be here, James, and with such great panelists and all of you. What I want to talk about is some basics that seem to really be getting lost in this debate. Why do businesses invest here or abroad? What are the impacts of investment abroad on the United States, our workforce, on the economy, on economic activity, on manufacturing, which I represent? And why do we care about whether the United States continues its longstanding bipartisan support for strong investment rules backed up by ISDS? So why do businesses invest? Look, businesses, U.S. companies, U.S. manufacturers invest primarily here in the United States, but increasingly overseas as well. Why? They want to reach foreign customers. They want to engage in economic activity. We have the largest consumer market here in the United States. It's no wonder our companies and foreign companies, right, are investing here in the United States every day. The United States continues to be the largest recipient of foreign direct investment. Are these companies, whether they're in infrastructure or automobiles, from Germany, from Asia, from Canada and Mexico too, are they investing here to sell back home? They're investing to get to our consumer. And you know what? U.S. companies, when they invest overseas, they're doing the same thing. And they're investing to participate in energy projects, resource projects, infrastructure projects that have to be done overseas. And when they're doing that, they're bringing with them U.S. exports, U.S. products, U.S. technology, U.S. R&D. And we'll get to the benefits for the United States. How do we know this? Is this just anecdotal, right? Like most of the claims of all the critics that Gary went through? No. Year after year, decade after decade, the Commerce Department's Bureau of Economic Analysis has looked at this. They've looked at where do U.S. companies, their foreign affiliates, who make $1 trillion in sales, where do those sales go to? Over 90% of the sales made by U.S. foreign affiliates overseas they stay outside the United States. They're not returned. This is not outsourcing. That's the belief. That's the supposition that underlies so much of the criticism you see out there. But when you start to think about U.S. investment abroad as reaching the 95% of the world that lives outside our borders, hopefully we can change that. So what's the impact on the United States? Huge and immensely beneficial. Gary was talking a little bit, didn't want to go into the wonky details. I will a little bit. U.S. companies, U.S. manufacturing companies that invest abroad are our largest exporters. 47% of those exports are because of our foreign affiliates overseas. And that doesn't surprise any of us. You tailor products, you set up distribution channels. There are a lot of reasons that companies invest overseas that benefit not just that company, an entire supply chain of companies and their workers here in the United States. These companies that invest overseas, are they leaving the United States? No. They invest billions, hundreds of billions of dollars in R&D and capital expenditure here in the United States. They are outsized investors in the United States because they are able to achieve economies of scale, reach new customers. They're able to export some of those higher tech components as well as the R&D and all of that. And the final point, which seems to be completely lost, U.S. companies that invest overseas, they pay their U.S. workers more, right? Because they're able to move up the value chain. They're able to be more globally competitive, and they pay their U.S. workers more. Why should we care about investment rules? Why should we care about investment? All of that is case number one, right? But there's other issues out there. the rules that our investment agreements and treaties set out. The NAFTA, about 40 bilateral investment treaties. We have these rules with 14 of our 20 free trade agreement partners. They set those basic rules familiar to all of us from our Constitution. The Takings Clause, due process, equal protection, and then other longstanding rules, the Administrative Procedure Act. This is part and parcel of who we are as a nation and our values, and we're exporting those. But these are rules that help stop foreign governments from doing bad market distorting things that would otherwise harm workers here in the United States. So I'm just going to talk about one kind of wonky example. I don't know why they call it performance requirements. Maybe it's an economics term. I don't know. This is a chapter in NAFTA and in our investment treaties that prohibits governments from forced localization. You can't require that an investor use a certain percentage of domestic content or domestic workforce, or require technology transfer. And you can't incentivize that. And not only does this provision against forced localization, something that all administrations and all policymakers I talk to here in the United States want to address, it doesn't just stop the countries at the table, like the 3 NAFTA countries. It bans those governments from doing that with respect to any other country. Because if it didn't, right, if Mexico were, not allowed to say, well, we could require you, U.S. investor, to require a certain amount of domestic content, but it could do that with China or Russia, that wouldn't be fair. And that would disadvantage our manufacturers, our products here. This type of rule, it's not enforced by political risk insurance or anything else out there. In fact, this is the strongest rule in the international legal domain against forced localization. We should be wanting more of these agreements. We should want to strengthen that, which is exactly what the NAM is calling for in the NAFTA context, not going backwards on any of this. These are rules that help us. And Congress and administration after administration on a very bipartisan basis has recognized this. Gary talked about Elizabeth Warren. Congress took this on in 2015 directly. And I know there's people out there who say, oh, this is a litmus test for whether Democrats would support NAFTA. 60 votes against Elizabeth Warren on a bipartisan basis as she sought to eliminate ISDS from trade agreements. That's not where the congressional support is. There is strong congressional support. We've seen letters already. We've certainly seen the business letter I hope you all have in your hand today that talks more about the value of investment from over 113 sectors of the U.S. economy, representing hundreds of thousands of companies and the millions of workers that depend on those companies to succeed in a global economy. So look forward to the rest of the conversation, but hopefully if we start with those basics, we can get to the right endpoint.
Great, thank you, Linda. Well, Counselor, it's time for your opening argument here.
Good morning. I'm enormously privileged to speak again at the Heritage Foundation. It's home not just to my good friends Ted and Jim, but also to my friends John Malcolm and Charles Simpson. And particularly privileged to share the stage with Jim, Secretary Hofbauer, and Ms. Dempsey. So, and I'm also pleased that so many good friends have come today. I'm just the dispassionate oracle of the law here, and I'm going to discuss the rule of law issues that NAFTA's ISDS system has endeavored to embody, and also focus a little bit on the larger scheme of things. Now, to start with, there was a handout with the NAFTA cases, the request for arbitration, that I pointed out now because it might help guide things along. And I will give you some of the information which I hope is pertinent, even if it is a little bit esoteric, and I leave the inferences to your good offices. So before delving into NAFTA, it's really important to understand what ISDS itself is and does. And some people ominously call them the hidden omnipotent courts. They're not hidden, but they are somewhat powerful. And one commentator calls costs ISDS as entrenching beyond the reach of majoritarian control rules for the free movement of transnational capital. Now, ISDS exists for three critical reasons. Four, in fact, if you count the overarching reason. And the first is that it's believed to supply our investors abroad a measure of rule of law protection, and it's also meant to export our rule of law values to other nations. Then you have litigation in a foreign court often is complex, time-consuming, expensive, potentially difficult to enforce, which is not a problem you have with arbitral awards because you have the New York Convention, as well as the fact that many of the countries that are trying to draw foreign investment, they've got, shall we say, integrity issues in their courts which would make foreign investors less likely to come in the first place. ISDS is intended to abate, if not root out those problems. Second, arbitral awards ordinarily avoid a long appeals route, and because parties distrust the local legal system. And third, many of the arbitrators typically are agreed upon by both parties, and in this system, party autonomy is believed to be paramount. So now NAFTA and NAFTA's ISDS, established in '92, but incorporated into domestic law in November '93, NAFTA's ISDS panels are really creatures of the treaty on which their legitimacy rests. And Chapter 11, which is the investment provision, it concerns each state's treatment of investments made by nationals of other NAFTA parties. Article 1139 defines investments pretty broadly: equities, debt, enterprises, debt, equity securities, loans, real estate, other tangible and intangible property, and so on. Now, with regard to what's actionable, they're talking about mistreatment of investments like expropriation, denial of fair and equitable treatment, denial of minimum standards of treatment. And under Article 1110, the host state cannot expropriate without a public purpose, with discrimination, without due process of law, and without compensation. Now, NAFTA's ISDS mechanism is less institutionalized and more fragmented, and it relies mostly on ad hoc arbitration. Now, why does NAFTA Chapter 11 receive so much ink? It does so because of the high-stakes claims that are being brought. The United States has had a far greater success rate than its fellow signatories. We have had 21 NAFTA claims filed against us, if my numbers are correct, and I think they probably are. The United States has never lost a case. The ISDS panels have even awarded the United States attorneys' fees after the United States successfully defended against frivolous and otherwise non-meritorious claims. Right now, we have pending against us a $15 billion request for arbitration filed by TransCanada. We don't know what's going to happen. We don't know what's going to happen with that, but the home country of TransCanada, our northern neighbor, has been the sovereign respondent in 39 claims and has had awards leveled against it of more than $150 million. Most of these damages were taken home by American investors. Mexico has been sued in 24 claims and has had hundreds of millions of dollars in damages awards leveled against it. So altogether, under NAFTA, $30 billion have been asked for, and a very small fraction of it actually given out. So ISDS is, one can see it as more of a sword of Damocles hanging over the sovereign's conduct. rather than an inevitable death knell to any kind of regulatory behavior. Now, aggrieved foreign investors may bring independent arbitration proceedings against the host state. They seek compensation for losses because of the state's offending conduct. And ISDS panels, they're typically composed of legal experts. They can award compensation, and sometimes even they've begun to do this, injunctive relief. You know, I don't think it's come into NAFTA just yet to any great extent, but in other ISDS cases, because you have, as Secretary Hoffbauer mentioned earlier, we have had we're living in a world of more than 2,000 bits and MAIs and so on. So you've had thousands and thousands of awards, and some of them have begun to tell the sovereign what you can and cannot do, as opposed to just the amount of money that's kind of the fine for having done it. And I will address some of the important issues about NAFTA and ISDS jurisprudence broadly, because while NAFTA has some important differences with some other treaties, it also retains a great many similarities. And a few points right away to help contextualize what's going on. Article 1131 says that NAFTA tribunals shall decide the issues in dispute in accordance with applicable rules of international law. So that's the power to fill gaps left by the treaty and the forum's rules. And it's this resort to default principles of public international law. An arbitrator can consult what's called opinio juris, the opinions of jurists, state practice, customs, to arrive at an answer. And some people argue that it destabilizes ISDS by injecting some unpredictability. But others argue that the flexibility is important because ISDS poses difficult questions, unforeseeable by those who drafted the treaties, and the parties do act somewhat autonomously in choosing 2/3 of the panel. Then the NAFTA parties, they have the power to what's called reinterpret the agreement through the NAFTA Free Trade Commission when some discourse or prior case has revealed a contentious gray area. Investors don't always like it, but the parties have not thus far changed that particular scheme. Then something that's very underrated in ISDS and at NAFTA, it's called the exhaustion of local remedies. And, exhaustion of local remedies, it's got what used to be called diplomatic protection in the rest of public international law. It's got a fabled pedigree in international law because I kind of think of it as, from the Greek tragedy, The Libation Bearers, where you give somebody a chance to redress the alleged wrong. I mean, as sort of like Clytemnestra and the Libation Bearers. Exhaustion had a point. It acknowledged the sovereignty of nations, and it was supported by two rationales. You give them a chance to fix what they did wrong, and you give them the respondent nation a chance to build up its own system, build up its own judiciary by fixing it on its own rather than by having the mandate foisted on it. So, but NAFTA decided that, this could not be in the new world if we had to give investors the kind of protections that investors needed in order to go in and freely put their capital and resources into unreliable parts of the world and to raise employment and raise GDP in those jurisdictions. It could not be. So the received wisdom in many circles is that Chapter 11 implicitly waives the exhaustion requirement, and it requires investors to relinquish bringing actions under the law of any party or other dispute settlement procedures. Any proceedings with respect to the measure of the disputing party that's alleged to be a breach. And that's probably been among the most prominent breaks that ISDS and NAFTA generally have made from the past public international law regimes, because they decided to accommodate the new reality rather than fight against it. I will briefly touch upon the two principal fora where NAFTA ISDS panels are constituted. One is the World Bank's ICSID. Nobody outside international law knows what they are, what that acronym stands for. But it stands for International Center for the Settlement of Investment Disputes. It's not too far away from here. And it provides facilities for conciliation and arbitration of investment disputes between the contracting states and nationals of other contracting states. It's an Article 42 consults convention and general principles of international law to fill in the gaps. And under ICSID rules, an investment must satisfy several criteria. It must be a contribution made by an investor. The project must have had a certain duration, and there must have been risks of the transaction involved. Now, ICSID is interesting because it has, after an ICSID panel renders a judgment in a NAFTA dispute, you have the annulment committee, which can step in and nullify that award. But initially, the annulment committee would very rarely step in. It wouldn't do that as a matter of course, because again, the finality and the expeditiousness of ISDS was very important. But and they don't see themselves as substantive error correcting bodies, but it's changing a little bit. And the other one is UNCITRAL, forgive me, the United Nations Commission for International Trade Law. Now, I haven't seen any obvious preference that the community has for ICSID over UNCITRAL or vice versa. Maybe others disagree with me. But several UNCITRAL advantages over ICSID are that, if you think of them as advantages, are that provisional measures issued by an UNCITRAL body may be binding and may also be enforced in the domestic courts. UNCITRAL party may directly go to the domestic courts to seek a provisional measure. Confidentiality doesn't automatically attach in ICSID arbitration without the agreement of the parties, and I think it does apply. It does attach in UNCITRAL, and UNCITRAL rules explicitly provide that the tribunal may even order security for costs in order to protect the party against whom the measures are ordered. So, that's kind of the setting the stage of it. And I know I'm sort of running out of time, so I'm going to touch upon the most favored nation. I think that's an important feature, and the fair and equitable treatment, due process, minimum standards of treatment, very briefly. So, with regard to most favored nation, there's been a debate raging throughout ISDS that whether or not a third-party treaty which contains provisions for the settlement of disputes, that's applicable to an investor who's claiming that their rights have been breached. So let's say that Ilan and I have a treaty, and Ilan's national says that Sohan, you've also got a treaty with Jim, but you're treating me worse than you're treating Jim's nationals. In a situation like that, is that actionable? And the NAFTA tribunals in a case called in a seminal case called Pope and Talbot, held that the NAFTA signatories did not intend to treat each other's investors less favorably than those from other countries. So they were, I took it as a pretty unequivocal sign. And with regard to effect versus intent, you have this dispute in domestic law, you have that in international law, you have that everywhere. NAFTA tribunals say that the measure's practical effect is the main factor in deciding whether the claimant received less favorable treatment. and the evidence of intent is not even required to win a discrimination claim. We have a question about level of scrutiny. How much deference to the government should we give? And the way I look at it is that NAFTA panels have kind of been all over the place about this. In a case called Feldman, they said that they asked whether or not there was any rational justification in the record for the less favorable treatment, which was different from another panel's fear that if rational justification is all you're looking for, then it's kind of easy to manufacture. In short, the deference to the state that's okay in discriminatory effect cases may not always be appropriate in discriminatory intent cases. Last point about the substantive standards, that's what I call it in the book, and I just think that kind of it's a good umbrella to describe the fair and equitable treatment, minimum standards, due process, and all that. There are no big surprises as to the factors NAFTA tribunals use to decide whether the regulatory act should be upheld. They look at the process that was given to the investor. They look at the legitimate expectations. They look at whether the government's action was proportionate to the evil or ill identified, whether or not it's extant or preemptive. Then the tribunals have looked at, as an important point, the tribunals have looked at what's called creeping expropriations. And creeping expropriations basically are kind of like inching, I mean, the name sort of gives it away. Instead of encroaching on the rights of an investor or a class of investors in one fell swoop, they passed one law, and then a couple of months later they pass another law. A couple of months later, and so if the tribunal is too hard on the investor and says that, oh, you have to show me in one lump, one individual way that they have encroached on your rights, they may not be able to meet it. But if the investor is allowed to make creeping expropriation actionable and is able to furnish a good argument, then they tend to prevail. Concluding remarks would probably, there's a lot more to it, but I think I'm overstaying my welcome a little bit. The bottom line is that sometimes the answer is just in front of our eyes. And so much of the consternation about ISDS may go away or be diminished if the texts of the treaties negotiated are more suitable, if the rules of the fora that we submit these cases to arbitration, where we submit these cases for arbitration, if the rules are made better, because throwing the baby out with the bathwater is kind of like saying that we don't like some decisions that some domestic court has rendered, so let's divest them totally of jurisdiction, instead of passing a better law or getting more rule of law-oriented judges to adjudicate those cases. Secondly, personnel is policy. We know that in Washington, and we should know that everywhere. ISDS generally and NAFTA tribunals too are, they tend to be populated by learned jurists, practitioners, academics. It really is interesting. It's kind of like a turnstile. It's like the same people, a bunch of turnstiles side by side, the same people going in and out. And sometimes you're an arbitrator, and sometimes you are an academic, and sometimes you are the practitioner. It depends on the tribunal. And they have rules to help mitigate bias and all of that. But that's a different matter. And so the doctrines, there's professional diversity and richness of experience. And so the doctrines they build up retain the potential to be, a sophisticated step towards some stability and coherence in the grand scheme of things. And I've also argued that instead of dealing with the whole issue in sort of a blunt and blanket way, perhaps go sector by sector. There's no real reason why that can't happen. Maybe there are political reasons, but in terms of the treaty itself and the ISDS generally, and other treaties, there's no reason why it can't be that way. So that's kind of what I think. Thank you.
Thank you. Thanks so much for that comprehensive overview. I'll exercise the prerogative as the moderator to ask one question, and that would be, Linda mentioned it, but with the, do we have more? I guess we have another one. If someone want to just expand upon this notion that equates ISDS with political risk insurance, I'd be interested in hearing more about that. That's something that's been advanced recently, that argument.
I mean, I can start, and then, I'd really welcome my expert colleagues on this. Political risk insurance, right, is a very highly limited approach. It's extremely expensive. And so if you're concerned about small and medium-sized investors, which we are, and which actually are the most often users of the ISDS system, right? Absolutely, clearly, individuals, small and medium-sized companies. Political risk insurance is even more expensive and more difficult, and it only really gets to oftentimes the seizure of property, expropriation without compensation, as opposed to the whole other panoply, MFN, national treatment, the performance requirement, forced localization prohibition that I talked about. It's also a way that continues to shift the burden out of the foreign government that's taken the bad act to, maybe it's OPIC in the United States, so the U.S. government, so U.S. taxpayers, or it shifts it to an insurer, right? But it does not put the penalty on the foreign government that's engaged in the highly market distorting activity. And that's what we want to do, right? We want to create a deterrent so foreign governments don't seize property and engage in the other unfair actions or market distorting actions that they do. So it doesn't even come close, in my mind, to addressing all of the types of things that the investment rules in ISDS do quite well.
Let me just embellish that slightly. Years ago when I was in the Treasury, as you kindly mentioned, I was one of my tasks was to be on the OPIC board. The Treasury had a representative at that time. So I learned a little bit about OPIC, the Overseas Private Investment Corporation. The point of this is that this corporation is really small. Its coverage is quite limited, and it doesn't say anything to a multinational company which has invested billions, because the limit of its policies when I was there, probably about the same now, was like $30 million or something like that. Now, again, $30 million is a lot of money in my pocket, but that doesn't make any difference to Dow or, IBM or any other company. So it's ineffective. Now, there is the Multilateral Investment Guarantee Agreement in the World Bank, MIGA, but it's not a whole lot bigger. So this is not a practical answer for most multinational corporations, which do nearly all the foreign direct investment that we know of.
Good, thank you. Thanks. Well, very good. We have a few minutes for questions. We do have a microphone, so please identify yourself, your organization. Maybe we start with Dr. Broman over here, since he's one of the co-authors on this subject.
I'm Ted Broman with the Heritage Foundation. Wonderful panel. Thank you very much for addressing this important subject. Let me ask a slightly devil's advocate question. I can entirely appreciate the argument for having an ISDS between, for example, West Germany and Pakistan. That's perfectly sensible. Suppose, would anyone on the panel or all of you care to comment about the usefulness of having an ISDS in a bilateral either investment agreement or an FTA between two countries with well-developed court systems and well-established rule of law practices. Do we need ISDS in every agreement between every party, or is this primarily something that countries with well-developed rules of law need when they're doing agreements with places that are less well-developed?
Let me give two quick responses and then turn to the others. Firstly, I regard Canada, which I go to often, as a country with well-developed rule of law and very similar to ours. However, as Swan has said, I mean, there have been a lot of cases against Canada, and I think those cases which Canada lost, it appropriately lost. And so what that says to me is that a country, even with a well-developed rule of law, such as Germany, UK, and so forth, Sweden, you know, there can be defects, especially in the realm of regulatory takings or regulatory law. And I think this is a good counteraction against those. So that's point one. The second point is that I think trying to single out countries which are particularly bad actors and only have ISDS with them and then not have ones transatlantic or we're back.
Lobbyists desperately want to keep their special powers in NAFTA.
Oh, good. Please save those for future reference. So, yes, that's right. The corporate, well, in any event, it would be quite invidious to only have these provisions in, you know, with countries that maybe are a little bit short, and countries do recognize they're sometimes short on their judicial practices. So let me just take the TPP, which I know is dead now, at least so far as the U.S. is concerned. I mean, could you imagine a TPP which said, we're going to have this chapter, you know, with respect to Malaysia, we're not going to have it with New Zealand or Australia? I mean, this is nuts.
If I may add something, I think that just the only point I would like to add is that just because Canada as a whole has a good legal system doesn't mean that every province does, and certainly every province has to every matter, because not only is the national sovereign on the hook for regulating properly and not violating the terms of NAFTA, but so is every town, every province, everything. And so when we had our, if I remember correctly, when we had the Lowen Group case filed against the United States, I think it was primarily against the conduct of the state of Mississippi. So I think that helps answer the question, perhaps.
And, you know, one of the cases in Canada from one of our paper manufacturers was in the province of Newfoundland, and they had expropriated the property and then denied the company the ability to go into court, right? That's what the province did. You know, it's an interesting point here. We've heard that argument a lot. I think we do look at it case by case, but overall, it's about fair play. And Brian, who I think just had to walk out, and I have often you know, gone to our sports metaphors, right? You want a fair referee, right? So if you're in the World Series or the World Cup or whatever, for some of these cases that could be politicized, you want to have a really neutral, independent method of dealing of it. But I think it's also interesting, you know, the claims of, you know, the critics out there. I remember during the implementation passage in Congress of the Korea-U.S. Free Trade Agreement, and these critics said, look at all this Korean investment in the United States. There's going to be hundreds. And they had maps and showed where all of it is, right? Chicken Little. How many cases have been filed in the 5 years we've had the Korea-U.S. Free Trade Agreement? Anybody? Where are our talking little bags? Zero, right? Zero. You know, 2018, you know, how do you count the cases that have actually gone to arbitration against the U.S. in over 20 years? I've got a chart, happy to share it with folks at some point. There are thousands, right? You can't even see the cases against the United States. There are thousands of cases on private property under the Takings Clause, under the Administrative Procedure Act, and similar cases just in federal court in the United States, because we do have a good legal system. And the remedies in the U.S. legal system are not just compensation. You can have specific remedies. And oh, we haven't even looked at state courts. So, again, the arguments are really hyped up on the other side. It is a basic level of protection that, yes, we should have with as many governments as possible, but it's not really opening up to risk. There's no evidence of that whatsoever.
Think of it in terms of, I don't know how many lawyers there are in the room. Think of it in terms of diversity actions in federal court. Ilan, yeah, okay. Diversity actions in federal court. I mean, part of the reason that exists is that maybe the state courts are not going to be necessarily the most hospitable fora to the out-of-stater, which is why the federal court is believed to be that way. So it's all about finding that impartial arbiter.
You've been very patient here in front of me.
Thanks for the terrific panel.
He's a brilliant legal scholar. He just had
I'm
a
in a-
book. Just had a book come out.
Thank you so much, and I very much appreciate
You're not so bad yourself. Anyway.
your talk and everybody's. My question is on the relationship between national law and these arbitral panels. How much deference do national courts give to these arbitral awards, say when someone's seeking to enforce a judgment? So I guess in the U.S., we tend to be very deferential to arbitral awards. Does that vary nation by nation based on national law? And then what about an arbitral panel's assertion of jurisdiction, right? If someone claims, a company might claim, we're not even subject to this investment agreement at all, and an arbitral panel disagrees, do courts defer in those cases? I think I know of one case where the U.S. District Court did defer, but does that sound right to you? I have no other sense of what the relationship might be.
Could you identify yourself? Sorry.
Ilan Werman, an attorney here in D.C. and non-resident fellow at the Stanford Constitutional Law Center.
I think you're by and large correct about that. I think that the courts do defer because, as I said at the domestic courts do defer, at least in the United States. As I said at the beginning of my talk, NAFTA has been there's been the NAFTA Act, and it's now part of our domestic law, so that obligates our federal courts to give them the due deference.
There are cases, of course, Methanex, not Methanex, I'm sorry, Metalclad. One of the early cases by a smallish U.S. investor doing wastewater treatment was basically invited into Mexico, passed all the permitting or authorization required, and then built its facility, invested hundreds of millions of dollars, and then at the last minute, the local state government, for what appears to be entirely protectionist reasons, said, oh, no, you can't do that. An investor state petition was filed only after that, just to be clear, because people seem, oh, this is an environmental case. No, that's when the ecological decree was filed, right after, to try to justify what was actually just a very protectionist action by a state, a Mexican state action. That case resolved at the panel level in favor of the investor, although for cents on the dollar compared to what they actually lost. And then that was litigated again in a Canadian court when they were seeking the actual payment of that award. And so the New York Convention you mentioned, and all of that. But these are different strains of law, right? Under U.S. legal principles, we don't self-execute treaties or any of the rest of it. And it is somewhat different. I think I know the case you're talking about, had worked on some of that. You know, sometimes we've seen governments try to get around investor state by filing in a U.S. court and say, oh, well, you shouldn't have jurisdiction. And the case I've seen on that really looked at the facts and, you know, what is being argued here and what belongs in U.S. court under U.S. law versus what is rightly in a panel. But again, right, I mean, where is the case? Where's the smoking gun? I think you talked about this, Gary. where's the example? Because there's not one, right? There has been no panel that has found that a non-discriminatorily, widely applied public welfare regulation runs afoul. Because the only thing these panels are looking at, what NAFTA, what these other investment treaties are looking at, and the International Bar Association says this, legal scholars who actually have expertise in dispute settlement continue to say this, because it's only on these very limited grounds of discrimination, arbitrary unfair treatment, expropriation without compensation, forced localization, a few others here and there, but it is actually a very limited basis upon which any of these panels can act.
I think we have time for one more question. Over here.
Well, thank you so much for your talk today and all the interesting comments on ISDS. I have a question. It's a little bit broader than NAFTA.
And who are you?
Oh, my name is Alex McDonald. I'm a economics graduate student and a former Heritage intern back in 2012. But it's been a while. But I just had a question. It's a little broader than just NAFTA. It's about the effect of the argument for regulatory chill. And I know this is not many other developed countries that we have BITs and FTAs with bring up this argument in relation to public health and environmental regulation, and the effect that not just actual claims, which are very small, but the effect of governments being afraid of getting in disputes, that enough is enough to cause a regulatory chill effect. I don't know, like the Australia versus Philip Morris case is one example of that is used in the argument for this. I think, correct me if I'm wrong, but Australia, I think, even banned the signing of any further treaties with ISDS. So I was just wondering, you briefly mentioned the possibility of maybe some more modern ISDS clauses. Can you elaborate if this is something that might lead to that, and if so, what would that look like?
Okay, thank you.
Let me let my colleagues answer the substantive question, but I will put a challenge back to you. Since you're an economist, probably know your econometrics very well. Anybody who can actually bring some econometrics to bear on this allegation of regulatory chill, should get his degree and probably his first professorship right there, because I regard it as total bunk. But I would say there's no evidence that I've seen on one side or the other.
Do you want to start?
No, why don't you? take
So,
this?
name me a case, right? There's no case that's ever been cited. There was a very extensive analysis by a Professor Techa out of the Netherlands or out of Germany, and a colleague for the Dutch government when TTIP and ISDS was being very much in the news in the EU, and they looked at all the NAFTA cases and they looked at this issue, and they could find no evidence of regulatory chill. And you just gave the example, right, on Australia and plain packaging. What happened in that case? Australia won. Even before Australia won, there were dozens of plain packaging regulations being adopted in countries around the world, right? And we can argue about plain packaging as a theft of U.S. trademark or anybody's trademark, but that case, right, the bringing of that case chilled nobody, right? Those regulatory actions continue to go on. I think it is an argument it's a solution in search of a problem, or a problem, it's just, there's no there. In reality, in the cases that we've seen.
And I think that in most of the treaties I've seen, and we've all seen, you have exceptions carved out for, public health, trademark, all of those things, taxation. So I think that no chilling effect, really.
Yeah, okay.
Okay, just following up on that, I was wondering, since NAFTA specifically, Chapter 11 was one of the first ISDS clauses, I believe. Is that the case in NAFTA as well?
Yeah. Well, there are exceptions. Intellectual property, very rightly, is considered a form of property and investment that should be protected. There are exceptions. But again, this gets back to, can a government take action Yes, nothing in an investment treaty stops them. They just have to compensate only when they do bad things, when they discriminate, when they treat an investor unfairly, when they expropriate without compensation. The same sorts of things we have in our law for all time. So again, where is the problem we're trying to solve? In the letter that we left out with more than 113 industry associations across the entire sector of the U.S. economy, we called for some improvements in NAFTA, Chapter 11, because it is an early agreement, and there are gaps in there of things that should be done. And if we want to grow manufacturing, if we want to grow industry and improve good-paying jobs here in the United States, there are things we should do to make sure we do have a level playing field, and we're going to continue to push.
Well, we've run out, in fact, we've run out of time, but please join me in thanking our panel for this excellent discussion.